Hello there, everybody. Welcome to our next video in the series on Sue Juris, representing yourself in court. My name is David Bryson, and today we're going to get into the discovery phase, investigating your case. This will consist of discussing formal discovery, depositions, interrogatories, requests for production of documents, and requests for admissions. So without further ado, we're going to jump right into this broadcast, but not before we pull up our favorite backdrop screen from our Sue Juris Law for Beginners page. This is a great group on Facebook. You have to know somebody who's in the group because it is a secret group with 5,455 members. Sue Juris is spelled S-U-I-J-U-R-I-S. You can always send me a request. And I will add you to the group. But this is a great group, lots of great dialogue, people helping other people understand law and becoming empowered as a community, a lawful and a law knowledgeable community. So we invite you to be a part of that. This is an ongoing series. We've got 4 videos before this. You want to catch up on those. And we've got about 20 more ahead of us, but we promise you that you will get an awesome education on how to present yourself in court. And we like to use the word present rather than represent yourself, because you don't need to represent yourself. If you are there, you are presenting yourself in court. Okay, here. Okay, we're going to pull up the screenshot. You want to go ahead and get your paper and pen ready, and be sure to share this link with your friends. Okay. Well, for whatever reason, there we go. That's what we are looking for. Okay. So, investigating your case. Today we're going to get into informal investigation, formal discovery, depositions, and we're going to discuss advantages and disadvantages of taking depositions, taking a deposition, defending a deposition, and deposition objections, written interrogatories, the advantages and disadvantages of sending interrogatories and drafting interrogatories, which are written answers, and requests for production of documents and subpoenas and requests for admissions, where people will just really freely admit to facts in the case. So it's about whittling things down to the bare essential facts. That's what we'll be discussing in this phase, this discovery phase. So once the initial pleadings are filed, we'll discuss that in video 3. The parties to a lawsuit typically begin gathering evidence to prove that their claims are true and that their adversaries are not. This phase of a lawsuit is often called case investigation, fact investigation, or discovery. Think of it this way. Although you may personally know exactly what happened, now that you are in the formal legal system, you will have to prove it to a judge or jurors who know nothing about you or your lawsuit. And to make your task more difficult, your opponent will probably present a very different version of events. The upshot is that you should approach case investigation with 2 main questions in mind. 1, what evidence can I find that is legally admissible in court and will back up my claims? And 2, how can I best present my evidence to a judge or jury to convince them that I should win at trial? Case investigation takes 2 forms: informal investigation and formal discovery. Informal investigation includes all information gathering that you can do on your own, working with cooperative people or organizations both before and after a lawsuit is filed. Informal investigation encompasses such activities as 1, conducting interviews, 2, collecting documents, 3, taking photographs of damaged property, accident sites, or other pertinent objects or locales, and fourth, finding out about an adversary's insurance coverage. By contrast, formal discovery is a legal process that kicks in after a case has been filed. Formal discovery encompasses a number of investigatory tools, including 1, document requests, which are written requests to your adversary to turn over certain documents. 2, interrogatories, which are written questions to your adversary that the adversary must answer in writing under oath. 3, depositions, which are oral questions that the adversary or another person must answer in person under oath. And finally, fourth, requests for admission, written requests that your adversary admit under oath that certain facts are true or that certain documents are genuine. One big disadvantage of formal discovery is that it can be expensive. A major advantage, however, is that it doesn't depend on anyone's voluntary cooperation. That is, you can use formal discovery tools to compel an adversary or witness to provide you with information and documents. Informal investigation. Informal investigation consists primarily of gathering information and documents from people who will voluntarily cooperate with you. You can informally question or seek documents from anyone, including eyewitnesses, public agencies, and police officers. If you are not an attorney, you can also seek information directly from your adversary, even if the adversary is represented by a lawyer. Lawyers can talk only to an adversary's lawyer. Obtaining information informally obviously saves the time and expense of formal discovery methods. Like many lawyers, you may be able to gather all the evidence you need to prove your claims or to disprove your adversary's claims through informal investigation. Caution: be aware of unauthorized investigation laws. Some states have unauthorized investigation laws that make it a misdemeanor to investigate without a license. If your state has this kind of law, it almost surely does not apply to you if you are self-represented and investigating your own case. However, the law may prevent you from asking a non-licensed friend to question witnesses or perform other investigatory acts on your behalf. As an example of how informal investigation might work, let's assume that you are involved in an auto accident in which an uninsured driver ran into your car. Because you do not have uninsured motorist coverage, you file a lawsuit on your own. You may do any of the following types of information gathering. Obtain a copy of the report prepared by the police officer who came to the scene of the accident by going to the local police station and paying a small fee. This accident report may include statements made by the other driver that will help you prove that the other driver was at fault. The report may also give the names and phone numbers of bystanders, including the police officer, whom you can try to question informally. Interview eyewitnesses, and if their information, this is the second thing you can do as far as informal gathering. 2, you can interview eyewitnesses, and if their information is helpful, serve them with subpoenas requiring them to appear in court once you have a trial date. Among the ways of finding eyewitnesses in an auto accident case are getting their names from a police report, talking to bystanders right after an accident, posting notices in the vicinity of an accident that ask eyewitnesses to contact you, and even putting a notice in the classified section of a local newspaper or online. Here's a tip: gather evidence promptly. Memories fade and scenes change. If you intend to photograph a scene or interview witnesses, do so as soon as possible after an accident or other event that may become the subject of a lawsuit. Any substantial delay may result in your questioning a person who no longer remembers the events. Similarly, Physical changes in a location, road, or piece of equipment may occur over time, perhaps depriving you of evidence that would have been useful at trial. And then finally, the final way that you can gather information informally is to prepare audio tapes or written statements at the conclusion of interviews. Be sure that the witness signs a written statement or states on an audio tape that you are recording the conversation with the witness's consent. An audio tape or written statement should refer to the important facts supporting your version of the events and should indicate the date when it was created. While audio tapes or written statements usually are not admissible in evidence at trial, they can nevertheless be extremely valuable during a trial when used to refresh an uncertain witness's recollection or cross-examine witnesses who change their stories. Also, prompt preparation of an audio tape or written statement setting forth facts favorable to you may discourage a witness from later changing a story to favor the other party. Here's a tip. Use written statements and audio tapes to improve your negotiating posture. Written or orally recorded statements can help you negotiate a favorable settlement with your adversary or an insurance company if the adversary has insurance. Once an adversary or insurance company realizes that you have witnesses to back up your claims, your settlement proposals will be taken more seriously. We actually have a number of more ways that we can do informal information gathering. Take photos. This would be number 4 now. Take photos of your injuries, the damage to your car, and the scene of the accident. Use a camera that automatically superimposes dates on photos, or write the date that a photo was taken on the back promptly after you develop the photo. Either you or a friend can take the photos, but no matter who wields the camera, anyone with personal knowledge of what a photo depicts can lay the groundwork for the photo to go into evidence at trial. Information on how to get photos into evidence can be seen in video number 15. Number 5, obtain from your doctor a copy of a medical report describing your injuries, course of treatment, and the likelihood of future physical problems. 6, secure receipts for all medical treatment, psychological counseling, physical rehabilitation, and any other out-of-pocket expenses resulting from the accident. Sometimes you can recover these fees from the defendant even if your insurance company has already paid them. In addition, these expenses document the extent of your injuries and add to any damages you might claim for, quote, pain and suffering. 7, if the defendant claims that some other person or business is responsible for the harm you suffered, such as saying, the auto repair shop put defective brakes in my car, ask the defendant for supporting documentation, that is, copies of the brake repair records and any records relating to brake inspections. If the information supports the defendant's claim, you may decide to name the repair shop as an additional defendant in the lawsuit. 8, examine a county's land records to see whether the defendant owns real estate in the county. Also, check court records to see whether the defendant is involved in any other litigation. This information may help you decide whether the defendant has assets from which you can collect a judgment. Here's another tip. Ensure that evidence is admissible at trial. Gathering information serves little purpose beyond possibly helping foster settlement if you can't use it at trial. Because most documents and objects won't waltz into evidence by themselves, you or another witness will have to sponsor them with appropriate testimony showing the judge that they are authentic and in good condition. In other words, you will need to produce at trial the favorable witnesses you've talked to informally. The suggestions below will make it easier for you to offer the fruits of your investigative labor into the evidence should your case go to trial. 1, Keep originals of all documents in a safe place for court. Make copies to show to witnesses or to attach to pleadings. Do not use the originals. 2, do not add writing or punch holes in the original documents. 3, during an interview, ask witnesses for the names and phone numbers of friends or relatives who will know the witness's whereabouts should they move before your case goes to trial. 4th, if you know your trial date when you interview a favorable witness, serve the witness with a subpoena at the time of the interview. A subpoena is a court order requiring a person to come to court. You can pick up a subpoena at a courthouse. For more information, see requests for production of documents and subpoenas. This will save you the trouble of finding the witness a second time to serve a subpoena. If you want the witness to bring documents or other evidence to court as well, you will need to serve a subpoena, duces tecum. And how to fill that out, the subpoena duces tecum. A subpoena duces tecum is an official court form available at a courthouse clerk's office or online. To complete this form, identify the documents you want a witness to bring to court. Fill in the name of the person who has custody of them. If you are serving a business or government agency, you may simply refer to the custodian of records. And state the relevance of the documents to your case. For example, assume that you want to prove that you have just installed an expensive CD player system in your car, which was subsequently totaled. You might serve a subpoena duces tecum on the bookkeeper of the company that performed the installation, asking the bookkeeper to bring to court copies of all records pertaining to the installation of the CD player, and stating that you need the records to prove your property damage in a car accident case. 5thly, keep any tangible objects you want to offer into evidence. For example, a damaged stereo. Keep them in a place where friends and family members cannot meddle with them, preferably under lock and key. This precaution will enable you to defeat an adversary's possible claim that an object should not be allowed into evidence at trial because it could have been altered or tampered with. And then 6thly, take photographs of the damaged item, especially if it's too large to bring to court or if its condition is likely to change before the date of trial. You can offer photos into evidence even though your own testimony or that of another witness who has seen the damaged item and can testify that the photo accurately depicts the item's condition. When requesting copies of documents, you can encourage voluntary cooperation by being very specific about the information you seek. For example, assume that you sue the chicken feed restaurant after coming down with what you believe was food poisoning. It is important to know whether records in your local county health office can help you prove that the chicken feed was responsible for your illness. If you ask for all records pertaining to the chicken feed restaurant, a health office employee facing hours of hunting for documents, many of which may not be germane to your case, may reply, "Sorry, you'll need a court order." But if your request is easier to deal with, for example, "Hey, I'd like a copy of records of any sickness reports made by patrons of the chicken feed restaurant during last July and a list of the restaurant's health code violations for the past 2 years." You may get the information promptly without a court order. You may get the information promptly without a court order. Some sources may initially be reluctant to disclose information, perhaps fearing that they can be sued for violating a person's privacy. However, don't give up without trying a bit of persuasion. Explain, first, that the information the person has pertains to a case that has already been filed in court. And secondly, that cooperation is easier for everyone because if you can't get the information voluntarily, you may have to take the person's deposition or serve a subpoena that will require the person to turn over the documents you seek. Finding evidence and witnesses may take a bit of ingenuity, perseverance, and maybe even a little help from your friends. Here are some tips to get you started. 1, do your own field investigation. In one case, law students represented a woman who was seeking to collect unemployment benefits after she was fired by a casino. The casino claimed that the woman was not entitled to benefits because she had carelessly allowed a stack of gambling chips to be stolen by leaving them on a counter to which the public had access. To investigate whether the casino's own carelessness could have led to the theft, the law students went to the casino and noticed that a metal grate had recently been installed in front of the counter where the theft occurred. They took a photo of the grate. The photo convinced the hearing officer that the absence of a grate and not the woman's carelessness had led to the theft of the chips, and the woman was awarded unemployment benefits. Secondly, if you are trying to contact a witness for whom you have a name but no other identifying information, check with government agencies such as a motor vehicle department or a utility company. If these agencies are uncooperative, which is a real possibility, and if a witness is important enough and the amount of money in dispute justifies it, consider hiring a private investigator to locate the witness, or try using an internet search engine to hunt for an address and phone number. Thirdly, if you are suing a former employer for firing you illegally, consider talking to former employees about their experiences and knowledge of company policies. Fourth, if you are suing a moving company for damaging and losing your personal property, collect insurance records, purchase receipts, photographs, and the like to prove ownership and condition of the lost or damaged items. And then fifthly, if you are suing a government agency, look in your local public library for reports and relevant statistics concerning the agency's operations. Here is a tip. Large businesses and institutions often insist upon subpoenas. Parties to court cases often want records from large organizations such as hospitals and telephone companies. Such organizations tend to protect themselves from an invasion of privacy claims by the person whose records you seek by releasing records only after being served with a subpoena. You may find an employee willing to talk to you off the record, but to secure evidence admissible in court, you'll probably need a subpoena. A good resource for informal investigation techniques is called How to Find Almost Anyone, Anywhere by Norma Tillman, Tillman, which is a private investigator's how-to book of techniques for searching for missing persons with an emphasis on tracing relatives. Now, moving on to formal discovery as opposed to our last section, which was informal discovery. The word discovery refers to a number of evidence gathering tools that the legal system makes available to you to compel your adversary, witnesses, and others with information about your dispute to answer questions and produce documents before your case goes to trial. Under Federal Rule of Civil Procedure, Rule number 26, Section B, you and your adversary may seek any information that is relevant to the claims in the pleadings. This includes identifying people who have the information and how to contact them, as well as descriptions of records, documents, and other tangible items. Amendments to the Federal Rules of Civil Procedure, Section 26, that took effect in 2006, extended discovery to electronically stored information, such as email messages and computer files, even if you have never printed them out. Under the Federal Rules of Civil Procedure 26, Section E, parties may have to supplement responses they've already given that later turn out to be incomplete or incorrect. In general, the three goals of formal discovery are: 1, to uncover evidence that favors your story; 2, to uncover the evidence that your adversary is likely to offer against you if the case goes to trial; and then 3, to lock the adversary into a story before trial so that you can attack the credibility of witnesses who testify at trial to different stories or facts. Again, the three goals of formal discovery are: 1, to uncover evidence that favors your story; 2, to uncover the evidence that your adversary is likely to offer against you if the case goes to trial. And thirdly, to lock the adversary into a story before trial so that you can attack the credibility of witnesses who testify at trial to different stories or facts. One of the primary limitations on discovery is that you cannot ask about privileged information. For example, private conversations between your adversary and the adversary's lawyer. Another limitation is that you normally cannot obtain information about your adversary's trial preparation work and materials, often called work product. For example, you can't ask your adversary, how does your lawyer plan to cross-examine me and my witnesses? Finally, judges have the power to limit or forbid discovery if requests are unreasonably cumulative, or if a court order is needed to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. Laws setting up formal discovery methods were first enacted in the 1930s by legal reformers who believed the information exchange would promote justice by fostering settlement and cutting back on the surprise aspects of trials. Reformers also hoped to conserve judicial resources by leaving the discovery process largely in the hands of the litigants themselves, involving judges only if litigants were unable to resolve discovery disputes. Unfortunately, over the years, lawyers have found ways to move battles that formerly took place in the courtroom into pre-trial discovery so that the reformers' hopes have been only partially realized. For example, some lawyers try to avoid complying with discovery requests by claiming ambiguities in questions that any 2-year-old would understand. Other lawyers, often representing big corporations, may drive up the cost of litigation, both to their own clients and to their adversaries, by swamping individuals and small businesses with burdensome discovery requests in order to coerce them into giving up or settling cheap. As a result, many state and federal courts have streamlined their discovery rules in an effort to combat such abuses. For example, many states have a disclosure rule similar to Federal Rule of Civil Procedure 26, Section A. This procedure requires parties to disclose key information voluntarily without waiting for their adversaries to request it. The data that parties are supposed to disclose include the identity of expert and non-expert witnesses, relevant documents, tangible objects, and insurance agreements that might cover all or part of a judgment. If the source of a disclosure consists of electronically stored information, such as information in email messages, a mobile telephone, or a PDA, under Rule 26F, the disclosure should identify the electronic source. Federal Rules of Civil Procedure 26A, subsection 3, requires additional voluntary disclosures in advance of trial. At least a month before trial is scheduled to begin, each party must disclose to the other the names and telephone numbers of their witnesses and identify any deposition testimony and all documents that the party plans to offer into evidence. The purpose of requiring these pretrial disclosures is to prevent surprise at trial and help the trial proceed smoothly. In addition to requiring voluntary disclosure, local discovery rules may also limit the number of questions that parties can ask and may set strict time limits for completing discovery. Also, parties often have a responsibility to meet and confer to set up a mutually acceptable discovery plan and to sort out any disputes before dragging each other into court. When parties disagree over whether information is discoverable, judges often speed up the process by conducting discovery hearings by phone. Judges are increasingly willing to impose sanctions, ranging from monetary penalties to dismissal of cases, on parties who abuse discovery rules. Judges will expect you to follow discovery rules even if you are self-represented, so you should seek the advice of a legal coach if you are uncertain of your discovery obligations. Here's a tip. Which is better, informal investigation or formal discovery? Self-represented litigants in small cases especially should attempt to get necessary information by first using informal investigation techniques, particularly to gather information to support their own legal claims. Formal discovery tends to be expensive and complex. Formal discovery tends to be so expensive and complex that even attorneys often forego it unless a substantial amount of money is in dispute. If your case is a good-sized one, or if you plan to use formal discovery methods for some other reason, follow these general guidelines. 1, take a deposition, which is a formal discovery a formal discovery method that we will be discussing shortly. Take a deposition to preserve helpful testimony from a witness who may not be available when the case goes to trial, perhaps because the witness is ill or about to move to another state. 2, consider preparing requests for admissions, another formal discovery device discussed below, to force your adversary to admit quickly that some of your factual claims are accurate. And then finally, use formal interrogatories, which are written questions, and possibly depositions, to find out about your adversary's case only if informal methods don't work. Now, even if you don't choose to use formal discovery methods, your opponent might. The rest of this video explains how formal discovery works. We briefly examine the 4 primary tools of formal discovery: depositions, written interrogatories, requests for production of documents, and requests for admissions. Now here's a tip. Pay attention to discovery deadlines. Judges and court rules often set and enforce strict discovery schedules and time limits. For example, a judge may order that all depositions are to be completed within 30 days, or that, quote, no discoveries to take place within 30 days of the trial date. Mark such deadlines on your calendar and plan to abide by them strictly. If an unexpected delay arises or an adversary's misconduct prevents you from meeting a deadline, you may have to ask the judge for extra time by filing a motion for extension of time to complete discovery or some similarly named document in court. A simpler alternative is to ask your adversary to stipulate or agree to an extension of time. However, this will probably not work if your adversary has intentionally caused the delay, or if your local court follows a fast-track pretrial system that aims to reduce court backlogs by setting short time limits and giving only judges the power to extend them. Now, let's jump right into depositions. Now, depositions normally consist of face-to-face questioning in an office setting. It's described in Federal Rules for Civil Procedure 27 through 32, outline deposition procedures in federal court cases. Most states have similar procedures. You can depose anyone you have reason to think has information relevant to your case. This includes your adversary, an expert witness hired by your adversary, or a potential witness for you or your adversary. In style, depositions resemble courtroom testimony. A court reporter places a witness, colorly called a deponent, under oath and records the testimony and may videotape or audio tape it as well if the party taking the deposition requests it. The court reporter later produces a written deposition transcript. The deponent is supposed to look over the transcript, change answers if necessary, and sign the transcript. But if a deponent does not significantly change an answer, you can try to undermine the deponent's credibility at trial by offering evidence of the change to the judge or jury. What happens to a transcript after a deponent signs it varies from state to state. In many states, transcripts are filed in court once they are signed. In other states, the party taking the deposition keeps signed transcripts, filing them in court only if the party intends and is legally entitled to read from the transcript at trial. Now, although you always hope to uncover evidence helpful to your case, a deposition's main purpose is to help you assess the strength of your opponent's case by learning in advance how much harm an adverse witness may cause you if the case goes to trial. This bears repeating. Although you always hope to uncover evidence helpful to your case, a deposition's main purpose is to help you assess the strength of your opponent's case by learning in advance how much harm an adverse witness may cause you if the case goes to trial. For this reason, you gain nothing by trying to avoid harmful testimony at a deposition. If a witness has bad things to say, better to find out about it as early as possible than to be surprised by harmful testimony in the middle of a trial. During a deposition, you also have a chance to observe a deponent's demeanor, allowing you to estimate whether a judge or jury is likely to believe the person's testimony. A recent report issued by the Federal Judicial Center demonstrates the importance of depositions in civil cases. Based on information from more than 1,100 attorneys, the report indicates that attorneys take one or more depositions in about 2/3 of all cases. The report cautions that depositions are by far the most costly aspect of pre-trial discovery procedures. You can read this report, a comprehensive snapshot of current discovery practices and problems, on the Federal Judicial Center's website at fjc.gov, Federal Judicial Center, fjc.gov. Choose the Publications and Videos link, click on the Browse by Title, and under A through D, look for Discovery and Disclosure Practice, Problems, and Proposals for Change. Now let's discuss advantages and disadvantages of taking depositions. Now, the four main formal discovery tools often work best in combination. For instance, you may send out a set of written interrogatories to uncover witnesses your adversary knows about, and then take depositions of those witnesses, and finally send your adversary a request to admit that a fact testified to by a witness in a deposition is true. However, because formal discovery can be expensive and time-consuming, you should be aware of the general advantages and disadvantages of each discovery tool. Advantages. Now, depositions. Advantages. Depositions generally have the following advantages. 1, they include testimony of unavailable witnesses. You can offer a deposition transcript into evidence at trial if the deponent is unavailable to give live testimony. This rule explains why you might consider deposing a helpful witness who may not be available to testify at the time of trial. By contrast, the hearsay rule would probably bar you from offering an informal written statement or audio tape into evidence. Another advantage of the deposition is that you can use it for impeachment. If an adversary's witness whose deposition you have taken testifies significantly differently at trial than at the deposition, you can read the inconsistent deposition testimony into the trial record to impeach, or that is to attack, the deponent's credibility. By contrast, impeachment is not nearly as effective if a judge or jury hears only your testimony that a witness told you something different informally. So here's an example. You have sued your former employer for violating state law by firing you for missing work because you served on a jury in a lengthy trial. Before trial, you take the deposition of your former supervisor, Paul Chepik. At the deposition, Chepik testified that your work performance had been satisfactory before you were called for jury duty. At trial, Chepik testifies that you were fired not because of your jury service, but because of a number of work-related problems. Because Chepik's deposition testimony contradicts his trial testimony, you could read the deposition testimony into the record at trial to call his credibility, that is, how honest and believable he is, into question. For more on using deposition testimony to attack a witness's credibility at trial, look forward to video number 13. Here is another advantage of the deposition: flexibility in questioning. As compared to conducting discovery by asking written questions or interrogatories, depositions allow for more flexibility in questioning because you hear a deponent's answer before you ask the next question. For example, assume that a deponent unexpectedly refers to an important business meeting that you didn't know about. In a deposition, you can immediately follow up the remark with questions about what took place during this meeting. By contrast, you have to prepare all of your written interrogatory questions ahead of time before you know any of the witness's answers. Sending out a second set of interrogatories is a possible option when a first set turns up unexpected information, but this is unwieldy and often requires a judge's permission. Another advantage: you can reach all witnesses and not just your opponents. Not just your opponent's witnesses. You can take anyone's deposition. You can depose your adversary, an employee who works for your adversary, or an ordinary or expert witness hired by your opponent, even your opponent's attorney. For an expert, you'll probably have to pay an hourly fee, which can be quite high. But an ordinary witness is usually reimbursed only for travel expenses to attend the deposition. By contrast, you can send written questions, which are interrogatories, only to your opponent, not to an ordinary or expert witness. Here's another advantage of the deposition: get witness, not attorney answers. So you elicit the testimony of an individual deponent. Though your adversary's lawyer will probably attend the deposition and can consult with the deponent during recesses, that is, breaks during the deposition, it is the deponent who has to answer the questions. By contrast, attorneys often play a major role in preparing the answers to written interrogatories and usually help their clients answer them in a way that provides you with as little information as possible. Here's another advantage: to obtain documents. You can use a deposition to learn about and get copies of documents or other tangible items by simply using a notice of deposition for your opponent or a subpoena ducis tecum for a non-party witness to list documents you want the deponent to bring to the deposition. And then finally, the final advantage is to size up your opponent. A deposition gives you a chance to observe your adversary's lawyer. The lawyer's behavior at deposition is some indication of what you can expect in court, and having already dealt with the lawyer at a deposition can reduce the chances that you will be intimidated in the courtroom. And here are some disadvantages of the deposition. Now, unfortunately, deposing an adversary or a witness who supports your adversary also has considerable disadvantages. Weigh these considerations very carefully before you decide to take a deposition. Cost. Depositions are the most expensive of the discovery tools. Even if you are representing yourself and therefore not paying an attorney to take or attend a deposition, you must pay a court reporter to transcribe the testimony and prepare a written transcript. While costs vary somewhat by locality, it's not usual for a court reporter to charge up to $5 per page of transcript. A day of deposition testimony fills up about 150 pages, meaning that a day-long deposition may cost you around $750. You probably won't have to purchase a transcript if you simply attend a deposition taken by your adversary. If you want and have the legal right to use at trial a transcript that you haven't purchased, you might have to send the adversary a subpoena to make sure the adversary brings the transcript to trial. If you lose the case, however, a judge might order you to pay your adversary's deposition expenses. By the same token, if you win, ask the judge to order your adversary to pay your deposition costs. Another disadvantage is that witnesses may lack knowledge. If you haven't investigated a case thoroughly enough to know which witnesses are most likely to have important information, you may end up paying dearly to depose a witness whose main answers are, "I don't know." By contrast, written interrogatories give you access to corporate knowledge. When you send interrogatories, demanding written answers to an adversary that is a business or other entity, the business must answer the questions with information known to the company as a whole, which means the business is responsible for figuring out who has the answers. So, for example, you have sued a record company for releasing a song that you believe violates your copyright. You take the deposition of Jan Winter, a record company executive who you think was in charge of releasing the song and therefore knows all about the decision to publish it. However, at the deposition, Jan testifies repeatedly that she had nothing to do with the song because she worked in a different division of the company until after it was released. You spent lots of money and learned nothing. Now, by contrast, if you had first sent written, requests for written answers, if you had sent interrogatories to the record company asking for the names of people in charge of releasing the song, you might have been able to target the most knowledgeable deponent. Here's a tip. Ask your adversary to designate a deponent. When your opponent is an organization and you are not sure whom to depose, consider asking the adversary to identify and bring to the deposition the most knowledgeable employee. For example, in the record company case, your notice of deposition might have directed the company to produce for deposition the employee who is most knowledgeable about the process by which the song is developed and published. See Federal Rules of Civil Procedure 30, Section B, subsection 6. If the adversary tries to give you a hard time by producing someone who knows nothing about the song, you could go to court and ask a judge to order the adversary to pay your wasted deposition expenses. Here is another disadvantage. A deposition is difficult to do well. Effective deposition questioning is a difficult skill, even for many attorneys. You have to pose questions carefully to figure out how adverse witnesses will testify at trial. If your questions are vague or you forget to cover a topic, you won't be prepared for your opponent's evidence at trial, and you may have trouble demonstrating that a witness has changed the story and therefore should not be believed. Another disadvantage is opposing attorney's presence. The opposing attorney's presence. Your adversary's lawyer will probably be present at a deposition. The attorney may throw you off track by objecting to your questions. An adversary's attorney can also help witnesses, quote, refresh their recollections, unquote, during recesses. Seeing you in action will allow the attorney to evaluate your credibility. And by listening to your questions, the attorney might learn more about your case than you learn about the adversary's. However, the same goes for you. Paying attention to how the other side answers and what the other side's lawyer does or does not say might help you anticipate their behavior in court. You may also find yourself much less intimidated in the courtroom after you have faced your opponent and survived the deposition. And then thirdly, another disadvantage is helping the other side. If you depose an adverse witness who becomes unavailable for trial, you enable the adversary to offer the deposition transcript into evidence at trial. Now, for taking a deposition. Once you've decided to take a deposition, you've got some preparation to do. First, noticing and preparing for a deposition. First, check your local court rules. Pay particular attention to when you can take depositions and how to notify a person whose deposition you want to take. You'll need to select the date and location for the deposition, arrange and pay for a court reporter's presence, check the phone book, and give the deponent and opposing counsel or your self-represented adversary at least 10 days written notice. Even better, as a courtesy, talk to all the necessary people ahead of time and arrange a mutually convenient date and location. Written notice procedures tend to differ depending on whether the deponent is the adverse party or some other person. In most states, you set up a deposition of your adversary by using a document called a notice of deposition. In some states, if you want the adversary to bring documents to the deposition so that you can examine them and ask questions, you can simply list those documents in the notice. However, in states that follow Federal Rules of Civil Procedure 30, Section B, subsection 5, you'll have to request documents by sending out a separate form called a request for production of documents. If you want to depose a non-party witness or someone other than your adversary, you'll probably have to serve the witness with an official court form called a subpoena re deposition. If you want the non-party witness to bring documents to the deposition, use instead a form carrying the fancy title Subpoena Duces Tecum Re Deposition. These forms should be available from a court clerk. List the documents you want the witness to bring along and state briefly how they pertain to the case. Legal form books, discussed further in video 23, contain simple language that you can adopt to your situation. Lawyers usually take depositions in their offices, but any office will do. If you have a convenient offer, or if you have a convenient office or can borrow one, use it. You'll probably feel more comfortable on familiar turf. Otherwise, you may arrange to use either your adversary's or the court reporter's office. Now here's a tip. Visually recorded depositions. Now, rules in many courts allow for visually recording depositions, usually in addition to having a court reporter present. While this procedure is optional and adds to a deposition's cost, a visual record can be particularly desirable if you want to preserve favorable testimony from a witness who may not be able to testify in person at trial. Showing a visual record of an unavailable witness's deposition testimony to a judge or jury is likely to be more impressive than reading a transcript of the testimony. Here's another tip: how to prepare to take an effective deposition. Follow these tips to learn as much information as you can at deposition. 1, prepare a list of questions before you take a witness's deposition. You need not slavishly follow the list, but having one should prevent you from forgetting important topics. Secondly, bring or subpoena copies of any written statements about the case that the deponent has previously given. For example, bring the police report if the witness gave a statement to the police officer, or the witness's own affidavit, which is a written statement signed under oath, if one was attached to a pleading filed in court. Ask the deponent about the events to which the statement refers. Then check to see if the deponent in any way contradicts the prior statement. If so, you might ask the witness to repeat the contradictory statement during the deposition. That way, if you impeach or attack the credibility of witnesses at the trial, the witness cannot easily wriggle out of your trap by saying, "Oh, I made a careless mistake during my deposition." Thirdly, bring copies of any other documents you want to question the witness about, regardless of whether the witness wrote the document or has any connection to it. For example, you may want to know whether the witness ever saw a document, the date on which the witness saw it, or whether the witness is aware of the information in the document. And then finally, review and bring along all paperwork relating to the case, organized chronologically, including the complaint, the answers, and any motions or court rulings. These documents can help if an adversary challenges the relevance of your questions. Now, as far as deposition questions. So, after noticing and preparing for the deposition, what do you do when it's time to start? before getting into the facts of a case, it's a good idea to begin with what lawyers call a deposition preamble or admonitions. This consists of a series of questions lawyers often ask to try to prevent deponents from discounting or weaseling out of their own deposition testimony at trial. Routine preamble questions include, are you currently under the influence of any medication? Have you had a chance to review any previous statements you've given to your lawyer or anyone else in connection with this case before coming here? Have you looked at any documents in preparation for your deposition? If the answer is yes, you may then ask, can you please tell me what documents you looked at? Have you had a chance to meet and discuss the case with your lawyer before coming here today? This is a fairly innocuous question. However, if you are deposing your opponent's attorney may object and instruct your opponent not to answer on the ground that your question calls for privileged information. That is, that answering the question would require the deponent to reveal what was said in a conversation with his or her attorney. This is probably an invalid objection because your question asks only whether a meeting took place, not what was said. Nevertheless, you can't force an answer, so if your opponent refuses to answer, just go on to your next question. A privilege objection is completely improper if you are deposing a non-party witness. There's no privilege for anything said between attorneys and witnesses who are not their clients. Here's another question. If you don't understand a question, will you tell me so that I can rephrase it? Do you realize that you are under oath just as if we were in a court of law? Is there any reason you can't give your best testimony today? The purpose of these preliminary questions is to undermine any explanation a deponent may come up with to excuse a change in the deponent's testimony at trial. For example, a witness who doesn't raise a fuss during the preamble and then contradicts testimony given at the deposition will have a tough time making an excuse such as, I couldn't concentrate at the time of my deposition because I was really feeling ill, or I hadn't had a chance to review the facts of the case with my attorney at the time of the deposition. Once past the preliminary questions, you can ask questions seeking case-related information. The scope of questions you can ask at a deposition is very broad, far wider than at trial. For example, you can ask witnesses about rumors they have heard or opinions they have formed, even though these questions would probably be out of bounds at trial, so long as the answers might, quote, reasonably lead to the discovery of admissible evidence. While each case is factually unique, the following general guidelines may help you think of questions to ask in your case. Ask questions that take a deponent through a story chronologically rather than by topic. Following a chronological format helps you understand the deponent's story and question more thoroughly. For example, ask questions such as, after the June meeting, what's the next thing that happened? Or, before you heard what you referred to as a squeal of brakes, did anything else happen? Ask wrap-up questions before leaving one topic to move to another. Wrap-up questions give deponents an opportunity to search their memories for details you haven't brought up. For example, before moving on from questioning a deponent about a meeting that occurred on June 1st, conclude by saying, is there anything else you can recall that took place during the June 1st meeting? The answer may be an unexpected windfall. But even if, as is usually the case, the deponent responds, I don't recall anything else, the answer can be very valuable. If at the trial the deponent suddenly remembers additional information that helps the other side, the answer allows you to cast doubt on the witness's believability by reading the contradictory deposition testimony to the judge or jury. Use a combination of open and narrow questions. Open questions may elicit information you would not have thought to ask, Open questions may elicit information you would not have thought to ask about and may encourage witnesses to describe events in their own words. For instance, please tell me everything that you can recall about the June 1st meeting. Now, narrow questions allow you to probe for precise information. Example, during the June 1st meeting, did Johnson say anything about upgrading computers? Also, refer directly to the allegations of the complaint or the answer when questioning your adversary. For example, your answer alleges that my own negligence caused the accident. Please tell me what I did that you think was negligent. Or, your complaint alleges that I was driving carelessly. Do you know of any witnesses to my alleged careless driving? Or, your complaint asks for economic losses you suffered due to my alleged breach of contract. Please specify the losses to which the complaint refers. So also continuing deposition questions. Show documents and tangible objects to a deponent and ask about their contents. To do this, you may use materials that you brought with you or that you asked the deponent to bring along. Now be sure to take the time to read documents carefully and study objects closely that a deponent brings in before you ask questions. For example, quote, your statement to the police officer indicates that you had left your eye doctor moments before you saw the accident. Please tell me why you went to see the eye doctor. Here's a tip. Marking exhibits. When you plan to refer to a document during deposition questioning, have a copy made, have a copy available, and ask the court reporter to mark the copy as an exhibit. For example, if you've questioned a deponent about a letter that the deponent wrote to Aunt Sally, ask the court reporter to, quote, mark this exhibit of the letter to Aunt Sally as Exhibit A. The exhibit will accompany the deposition, and you can refer to the document as well as the deposition testimony if you have a reason to use the deposition at trial. Use documents to refresh a deponent's recollection. For example, a construction worker says that he cannot recall what grade of wood was used on the exterior of your house. You may respond, please look over the construction agreement that's been marked as Exhibit A and see if that refreshes your recollection. Ask whether the deponent knows of any other person or document that might have information pertaining to your case. For example, you testified that the subject of computer upgrades was discussed during the June 1st meeting. Are you aware of any document, memo, or report that supports your testimony? Have you talked to anyone who mentioned having a memory of this subject being discussed at that meeting? Or, following the accident, did you talk to anyone who said that they saw any part of it? Now, if the answer is yes, say, please give me the names, addresses, phone numbers, and any other information you have that would help me to contact the persons you talked to. Moving on. No, don't be afraid to ask for details of unfavorable evidence. Remember that a deposition is your chance to find out how bad the case against you will be if you go to trial. Let me repeat. Don't be afraid to ask for details of unfavorable evidence. Remember, a deposition is your chance to find out how bad the case against you will be if you go to trial. A deposition is not the place to argue your side. As best you can, try to pretend you're representing someone else and trying to find out how the witness can hurt this other person. For example, if a deponent testifies to seeing you having drinks in a bar shortly before you drove off in your car, you might continue with open questions to encourage the deponent to describe events in the deponent's own words, such as, you testified that you saw me drinking in a bar on the night of the accident. Please tell me everything you can remember about my activities that night. Can you recall anything about my physical condition that night? You said that I seemed a bit tipsy. Please explain what you mean. Anything else you can recall? And then move on to narrow questions, asking for details. Over what period of time did you see me in the bar? You testified that you saw me holding a drink. Did you see how many drinks I had? Could you tell in any way what I was drinking? Ask questions concerning a deponent's general background. The information may suggest new topics for questioning and may allow you to estimate the deponent's general credibility. For instance, you may ask about a deponent's family background, including marital status, education, employment history, membership in organizations, relationship to your adversary, the adversary's lawyer or other witnesses, financial interest. In this case, this topic is particularly appropriate for an expert witness because the size of the expert's fee may suggest a motive for the expert to bend an opinion in your adversary's favor, and criminal convictions, if any. Probe a deponent's credibility by questioning the deponent's ability to observe and recollect. For example, you may ask whether a deponent has any special reason to be able to recall what happened months or years earlier, and you might ask whether the deponent has any physical limitations. Finally, you might also ask about any external conditions such as weather, darkness, background noise that may have interfered with the deponent's ability to see or hear what happened. Questions you may ask along these lines include, is there any special reason why you remember what took place during the June 1st meeting? Please describe your activities on the day that the accident took place, up until the time you heard the screech of brakes. Do you ordinarily wear glasses? If the answer is yes, were you wearing them at the time of the accident? Deponents can often be hard to pin down, especially when you try to elicit information they'd rather not provide. One good approach is to watch out for weasel words and qualifiers and insist on definite responses. For example, a deponent testifies, I might have left my glasses at home, because might have are clearly weasel words. You will want to follow up by asking, please answer yes or no. Did you leave your glasses at home? Look in a law library for lawyer practice guides that suggest areas of deposition questioning for specific types of cases. For example, a practice guide might suggest topics that you should probe in a breach of contract or an auto accident case. One well-known and quite comprehensive source is Bender's Forms of Discovery, a 10-volume treatise updated regularly. After you finish questioning the deponent, your opponent's lawyer can also ask questions. Often, opposing counsel will ask very few questions or none at all. This makes sense. The deponent is probably on your opponent's side, which means that your opponent can get additional information from the witness through informal questioning and outside of your presence. Caution here, watch the clock. Federal Rules of Civil Procedure 30, Section D, subsection 2, and similar rules in many states generally say that a deposition may last no longer than 1 day of 7 hours. This rule allows you to call a halt to a deposition that your adversary takes once time expires. If you are taking a deposition, make sure to ask all your important questions before time runs out. No matter which side is taking the deposition, you can agree to longer or shorter time limits with your adversary. Also, if your adversary's obstructionist tactics prevent you from completing a deposition within the time limit, you can file a motion asking a judge for additional time. If you do, be sure that your motion indicates what information you seek and why it's important. You can also ask the judge to sanction or penalize your adversary for your inconvenience in having to prepare and argue the motion. In some jurisdictions, a court officer might be available by telephone to resolve a dispute over time limits immediately. How a deposition background question paid off big time. In the mid-1980s, a group of families sued 2 Woburn, Massachusetts businesses for poisoning groundwater and causing town residents to suffer leukemia deaths and other physical injuries. during the deposition of the doctor who had important information that helped the plaintiffs. A defense lawyer asked about the doctor's marital status. The doctor mentioned an ex-wife who, after being tracked down by the defense, provided negative information about the doctor's personal background. The plaintiff's lawyer, fearing that the jury might learn this information, decided not to have the doctor testify at trial. So the plaintiffs lost a valuable witness based on the answer to a routine background question at a deposition. Defending a deposition. As a party to a lawsuit, you have a right to be present at every deposition your adversary takes. Lawyers call this defending a deposition. Lawyers occasionally save their clients money by skipping the deposition and ordering a transcript instead. If you are a self-represented party, you automatically defend your own deposition. We will include some suggestions that can help you or a deponent who supports your side of the case and is willing to meet with you beforehand to testify as completely, accurately, and credibly as possible. This is important because solid depositions strengthen the bargaining position. Moreover, following this approach should prevent you or another deponent from having to explain to a judge or jury why you or the deponent have changed your deposition story or can suddenly remember details at trial that were not mentioned months earlier at the deposition. Caution. Your adversary can ask about any pre-deposition discussions you have with a witness. Your adversary's lawyer can ask a witness what you said to the witness before the deposition started. Or, as lawyers put it, your pre-deposition discussions are not privileged. Therefore, don't say anything that would embarrass you or hurt your credibility if the witness were to repeat it during the deposition. The following tips can help you or your witness testify fully and accurately at a deposition. Just as you would do if you were getting ready to take a deposition, prepare in advance to defend a deposition. To do this, review the pleadings and any case-related written statements you or your witness made, such as demand letters sent to your adversary, affidavits attached to a pleading or motion. For example, as part of a summary judgment motion, see video 7, or even letters written to a newspaper about the incident giving rise to the lawsuit. Similarly, review all pertinent documents that constitute the paper trail leading to litigation. For example, in a breach of contract case, this would include any memos that you or a witness might have written before signing a contract and the contract itself. Don't volunteer information. Listen carefully to questions and answer only what you are asked. You or a witness may be tempted to defend your position with long, rambling answers, but such answers almost inevitably provide an opponent with useful information. If you really want a witness to elaborate on an answer, wait until the end when you will have a chance to ask questions. If you don't understand a question, or if a question is confusing because it has several parts, ask the questioner to rephrase it. Ask for a recess if you become mentally fatigued, need a bathroom break, or just need time to think. During this time, you can continue to refresh your recollection with notes or other documents. Object if you think that a question is improper. However, you should then go on to answer it unless a question is totally irrelevant or asks about legally privileged information. For example, conversations you've had with your legal coach. Tell the truth. Deposition objections. During a trial, lawyers and self-represented parties can object to each other's questions during depositions. See Federal Rules of Civil Procedure 30, Section C, subsection 2. See also video See also video 17 for a discussion of common objections and objection procedures. But because judges are not present at depositions, it is not possible to get an immediate ruling on your objection's validity. Typically, a judge rules on a deposition objection only if the side taking the deposition wants to read the objected to testimony into the record at trial and has a legal basis for doing so. If the trial judge determines that the objection was proper, the judge will probably not permit the testimony to be read at trial. Again, because judges are not present at depositions, a deponent normally answers an objected to question just as if no objection had been made. The fact that you or your adversary's attorney made an objection comes up later if one of you seeks to admit that portion of the testimony into evidence at trial, at which point the judge will rule on the objection. For example, an attorney defending a deposition may object that a question calls for hearsay, but then tell the deponent to go ahead and answer the question. The big exception to this practice occurs when the basis of an objection is that a, quote, question is improper because it calls for privileged information. Caution. An attorney may try to take advantage of you. If you defend a deposition as a self-represented litigant, pro se, or sui juris, an attorney might try to take advantage of you in the absence of a judge by bullying you or your witness. Bullying tactics include asking rapid-fire repetitive questions, using a raised voice, arguing with you, asking questions so far afield that they are outside even the broad scope of discovery, or if defending a deposition, objecting constantly. You can object to an attorney's questions just as you can at trial, which has the effect of preserving your objection for trial, as explained above. But if you're asking the questions, don't stop just because an attorney repeatedly objects to your questions. The attorney may just be trying to rattle you. Persevere with your questions no matter how obstreperous the attorney is. In an extreme situation in which an attorney is repeatedly insulting or excessive, it may be appropriate to terminate a deposition and promptly file a motion in court using the transcript as a basis to request a judge to impose sanctions or penalties on the attorney. A middle ground between stopping the deposition altogether and ignoring the bullying is to ask for a break and insist on it if necessary. Even a 5-minute bathroom break can interrupt the nasty momentum and give you a chance to catch your breath and regain your confidence. A good resource on depositions is NOLO's Deposition Handbook by Paul Bergman and Albert Moore. It explores deposition rules and strategies for self-represented parties, as well as information for non-party witnesses, including experts who face being deposed. Also, American Jurisprudence Pleading and Practice Forms, which is a multi-volume treatise that includes numerous examples of deposition forms. Let's talk a little bit about privileged information. As you've seen, deponents are normally expected to answer questions that may be legally objectionable, leaving it to a judge to rule on whether the answers can be used at trial later if an effort is made to introduce the information into the trial record. The big exception to this practice occurs when a question seeks privileged information. In all states and subject to various exceptions, legal privileges exist for confidential communications between attorneys and clients, spouses, physicians and patients, and ministers and congregants. Depending on a state's law, privileges may also exist in some other situations, such as between psychotherapists and clients. A privilege also exists for an attorney's work product, meaning an attorney's strategic papers and files. For general discussion of privileges, see An Introduction to the Law of Evidence by Graham Lilly, L-I-L-L-Y. When a legal privilege exists, the protection of privacy in the privileged relationship, for example, between doctors and patients, has been deemed more important than the need to get the information in any one case. Neither you nor any other witness has to reveal privileged matter, whether at a deposition or a trial. For example, you do not have to reveal the case-related private conversations you've had with your legal coach or a personal conversation you had with your spouse following a car accident or the making of a contract. Nor can you ask your adversary for a copy of the adversary lawyer's trial strategy memo, because that represents the lawyer's privileged work product. For example, you ask your adversary, "Please tell me what you and your attorney talked about before we started the deposition." The question calls for privileged information, and the deponent does not have to answer it. Example 2. Amanda, a self-represented litigant, discusses her case with a friendly witness before the adversary takes the witness's deposition. The adversary's lawyer asks, "What did you and Amanda talk about before the deposition?" The question is proper. Because Amanda is not a lawyer, no privilege exists for conversations between her and the witness. Deponents who are unaware of the protection for privileged material may unwittingly disclose it during a deposition, in which case the privilege is waived. That is why a lawyer who represents a deponent usually instructs the deponent not to answer a question that seeks legally privileged information. If you are self-represented, you don't have the right to instruct a deponent to refuse to answer a question that calls for privileged information. However, you can interrupt a deposition to advise a friendly deponent that a question calls for a privileged matter and leave it to the deponent to decide whether or not to answer it. A couple other resources. Basics of Legal Document Preparation by Robert Cummins, C-U-M-M-I-N-S. This reviews the fundamentals of various discovery tools and contains many examples and sample forms. And The Effective Deposition, Techniques and Strategies That Work by David Malone and Peter Hoffman. This is a comprehensive guide to deposition rules and techniques based on the Federal Rules of Civil Procedure. So all is not necessarily lost if you neglect to object to an improper question or answer during a deposition. You might be allowed to make the objection for the first time at trial should your opponent seek to read improper deposition testimony into the record. However, the safest course is to become familiar with grounds for objection and to make objections for the record whenever you are uncertain. You especially need to object if your objection concerns the form of a question or answer. For example, a question is leading or vague. You cannot make a form objection at trial if you fail to make it during the deposition. See Federal Rules of Civil Procedure 32, Section D, subsection 3, Section B. Moving on to written interrogatories. Written interrogatories are questions that you or your adversary must answer in writing under oath. See Federal Rules of Civil Procedure 33. Most states follow similar procedures. Court rules usually give the answering party, called a respondent, 30 days to answer. However, because answering interrogatories often requires searching records and gathering documents, judges usually grant parties motion for additional time to answer. Realizing this, parties usually informally stipulate or agree to a request by their opponents for a reasonable extension of time to answer. The advantages and disadvantages of sending interrogatories. Compared to depositions, written interrogatories provide the following advantages. Lower cost. Your only interrogatory expense is the time it takes you to prepare them. You don't have to pay a court reporter or arrange for videotaping or set a date and location. You simply prepare the questions at your convenience and serve them on your adversary by mail. Here's a tip. Save time and money by sending out interrogatories before taking depositions. Save time and money by sending out interrogatories before depositions. Interrogatory answers can pinpoint the witnesses who are likely to have important information, reveal documents that you can use when questioning witnesses, and supply background information that you would otherwise have to ask about during a deposition. As a result, your deposition questioning can target key witnesses and issues and therefore be shorter and more efficient. Broad scope is another advantage. The scope of your questions can be very broad. Whether you take a deposition or send out interrogatories, you can seek information, quote, reasonably calculated to lead to the discovery of admissible evidence. You can also get corporate knowledge, which is another advantage. When you send interrogatories to an organization, you are entitled to corporate knowledge, or the collective memory of all employees and representatives, not merely the single witness whose deposition you are taking. A typical preface to interrogatory questions instructs the recipient to, quote, furnish all information known by or in possession of yourself, your agents, and your attorneys, or appearing in your records. Example, you have sued a hospital for negligently allowing Dr. Rex to perform a medical procedure for which you claim that Dr. Rex was not qualified. You ask, please describe the process you followed to investigate Dr. Rex's qualifications to perform the above-mentioned medical procedure. An individual deponent might be able to testify only about a small part of the investigation. The interrogatory, by contrast, should reveal the combined investigation activities of various individuals. However, just like depositions, interrogatories have a number of downsides that often limit their utility. Remember, we advise you to rely on informal investigation to the extent that it is possible. Some of these disadvantages include limited number of questions. Court rules are likely to limit the number of interrogatories you can ask. Federal Rules of Civil Procedure 33, Section A, allows 25 questions, including a reasonable number of subparts, unless a judge gives you permission to ask more. Few states allow more than 50. Lack of flexibility in questioning. Court rules often limit you to a single set of interrogatories. Even if this isn't true, or a judge makes an exception in your case and allows a second set, you have to prepare and send out a whole set of interrogatories before you receive any responses. This means that you often don't have the information, the answer to your first question, that might allow you to make more pointed inquiries or follow-up questions as you normally would at a deposition. You can reach only the opponent, which is another disadvantage. You may pose interrogatories only to the opposing party. You cannot send them to witnesses or other third persons. And lawyers write the questions. Interrogatory answers are frequently prepared with strong input from lawyers. Lawyers tend to provide narrow answers that conceal rather than reveal helpful information. And they avoid answers entirely by claiming that questions are ambiguous, vague, unduly burdensome, seek impermissible legal conclusions, or violate the attorney-client privilege. These types of responses are especially likely if you represent yourself and your opponent has a lawyer. Though you can file a motion asking the judge to compel your adversary to answer your question, this process can be time-consuming and frustrating. For example, in a personal injury case, your interrogatory, which is again your written questions, asks, please identify the witnesses you have talked to or taken statements from and attach those statements or summaries to your answers. The probable response, objection. The question asks for the attorney's work product and is protected from disclosure under Federal Rule of Civil Procedure 26b-3. To avoid this objection, ask only for the names and addresses of witnesses, not for the attorney's decisions about which witnesses are worth talking to or taking statements from. For example, a proper interrogatory might be, state the full name and address of each person known to you who witnessed the claims to have witnessed. State the full name and address of each person known to you who witnessed or claims to have witnessed the collision between plaintiff and defendant's car on May 4th, 2000, whatever. If you want to know what the witnesses saw or heard, you'll have to interview them informally or take their depositions. Here's another example. You are the plaintiff in a breach of contract case, and your interrogatory says, please identify all documents in your possession that pertain to the case. The probable response: objection. The question is vague and overbroad. To avoid this objection, narrow your requests. For example, a more acceptable interrogatory would be, please identify any documents in your possession pertaining to conversations between Sam Spade and plaintiff relating to the contract described in plaintiff's complaint. Let's talk about summary responses. Lawyers rarely provide, and judges rarely insist that they provide, lengthy answers to broadly worded interrogatories. The legal culture generally allows for summary responses to open-style interrogatories, perhaps out of a sense that information should not be too available on the cheap. If you want to elicit a full story, you'll probably have to take a deposition. Example, you ask, please describe the process leading to the hospital's hiring of Dr. Rex. Instead of a lengthy, fully detailed answer, you're likely to get something closer to thorough review of past employment and numerous committee discussions and analyses. Now for drafting interrogatories. Without experience, you'll probably find it hard to draft clear, unambiguous interrogatories. One way around this problem is to consult a legal treatise such as Bender's Forms of Discovery, which has pre-drafted questions for specific kinds of cases. Unfortunately, Bender's won't be of much help if it doesn't have sample interrogatories for a case with facts similar to yours. Another possibility is to have your proposed interrogatories reviewed by your legal coach, if you have one. The coach can probably provide quick suggestions for tightening up your questions. 7 tips for drafting good interrogatories. The following suggestions should help you draft more effective interrogatories. 1. If court rules in your jurisdiction require parties to disclose pertinent documents and witnesses voluntarily, do not begin to prepare interrogatories until your adversary has completed disclosure and you've had a discovery planning meeting with the adversary's lawyer. That way, you'll have background information that can help you pinpoint specific topics for interrogatories. 2, because you can submit only to a limited number of interrogatories, use sub-questions to reduce the number of interrogatories you use to cover a single topic. Remember, however, that subparts must be reasonable in number. A judge won't allow you to evade limits on the number of interrogatories by adding 20 to 30 subparts to a question. For example, please state whether you wear prescription corrective lenses. If the answer is yes, please also state the vision problem for which you have a prescription and the prescription. Example 2. During the past 5 years, have you suffered any other personal injuries? If your answer is yes, please state for each injury. A, the date of the injury. B, where you were at the time of the injury. C, how the injury took place. And D, the nature and extent of the injury. E, the name and address of each medical facility or office in which you received treatment for the injury. And F, whether and from whom you sought compensation for that injury. 3, if you are going to ask a series of interrogatories about a single event or document, define the event or topic in a definitions section that comes before the questions. This way, you don't have to describe the defined event or topic every time you refer to it in an interrogatory. For example, definitions. The following term used in these interrogatories has the following meaning. The term September 22nd contract refers to the contract signed by plaintiff and defendant on September 22nd and attached as Exhibit A to these interrogatories. An example 2. Definitions. A request for any document refers to all writings of any kind, including but not limited to correspondence, memoranda, notes, pamphlets, books, computer printouts, fax documents, graphs, photographs, videotapes, and electronically stored records, whether stored on tapes, cassettes, computers, or other similar devices. 4. When you ask for information, also ask if your opponent has any documentation or record reflecting that information. If so, ask that they include a copy of the document with the answers. This saves you from having to seek the document in a separate request for production of documents form. Example, do you contend that you shipped the widgets to plaintiff on March 12th? If so, please state whether you have in your possession or control any document or record indicating that such a shipment was made, and attach a copy of any such document or record to your answers to these interrogatories. 5. Ask your adversary to set forth the facts on which the claims in the case are based. Example, you are the defendant in a personal injury action. The plaintiff's complaint asks for damages of no less than $100,000. You might submit an interrogatory such as, please identify separately each element of harm, economic, physical, psychological, or otherwise, for which you seek damages, the dollar amount you seek for each element of harm, and the facts constituting each element of harm. 6. When serving interrogatories on an entity such as a corporation, ask for, quote, the identity of each person who participated in preparing the answers to these interrogatories and the description, each document that was consulted in the course of preparing answers to these interrogatories. The answers can help you decide who to depose and what documents to request. And then finally, 7 tip out of tips for drafting good interrogatories. Make use of form interrogatories. Legal form books and attorney practice guides are available at any good-sized law library. Such guides typically contain sample interrogatories for use in specific types of cases. For example, a form book may have a set of plaintiff's interrogatories in a case about breach of a shopping center lease. Consult form books for your type of case before preparing a set of interrogatories. A good resource is called Resources on Interrogatories, or rather, it's called Bender's Forms of Discovery by Matthew Bender. It's a 10-volume treatise with sample interrogatories for numerous kinds of cases, including product liability, employment discrimination, slip and fall, and building construction. Another great resource is American Jurisprudence, Pleading and Practice Forms Annotated, and Basics of Legal Document Preparation. Moving on to requests for production of documents and subpoenas. We have so far discussed several ways of obtaining or inspecting and copying documents or other objects, including 1, making informal requests to cooperative witnesses or businesses, 2, asking for voluntary disclosure from your adversary, 3, using a notice of deposition or subpoena ducis tecum re-deposition to order a deponent to bring documents to a deposition, and asking a party to attach documents to its answers to written interrogatories. There are several additional methods for gaining access to written materials, including sending your opponent a request for production of documents. See Federal Rules of Civil Procedure 34. Most states have similar rules. And serving a non-party with a subpoena, ordering the recipient to allow you to inspect and copy designated materials. See Federal Rules of Civil Procedure 45. Many, but not all, states provide for this option. Rule 34 of the Federal Rules of Civil Procedure provides that electronically stored information is subject to discovery on the same basis as tangible written documents. By submitting a request for production, you can obtain email messages that your adversary has sent or received and information in your adversary's computer files. You may obtain this information even if the email messages or computer files have never been printed out. Of course, your adversary may obtain the same information from you. Generally, you should produce electronic information in the form in which you ordinarily maintain it. For example, if you store data that you have to turn over to your adversary in a Word file, you can provide your adversary with that file. You don't have to convert the file to another form. Here's a tip. E-discovery. Discovery procedures in the digital era. If you're involved in a lawsuit, you may request or be asked to provide electronic records such as email messages, social media communications, and digital versions of contracts and other records. Discovery rules apply with equal force to paper and electronic records. For example, you may refuse to produce a record that is privileged or constitutes your work product, regardless of whether the record is handwritten or electronic. However, the complexity of electronic storage techniques and the risk of accidentally deleting litigation-related electronic records can make electronic discovery a minefield, even for experienced lawyers. Here are a few suggestions that may help you deal with electronic discovery. If an electronic record is reasonably likely to be relevant to a future or current lawsuit, do not erase or conceal it. For example, if you operate a business and an employee is injured at work, keep all records relating to the injury or complaint. Intentional or even careless destruction of records may constitute spoliation, and a judge may decide that the missing information would have been harmful to your claims. Back up any records that may be pertinent to a current or future legal dispute, and download software to safeguard the records against accidental destruction. 3. Get into the habit of digitizing paper documents such as contracts, leases, and payroll records, and organizing the records into electronic folders. You then have electronic access both to the records themselves and the electronic metadata that computers invisibly imprint onto electronic records. 4th, consider storing important records in a cloud rather than, or in addition to, storing them in your own electronic devices. Using a cloud storage provider prevents your records from being lost to personal hardware failure, destruction, damage, or theft, while potentially freeing memory in your computer for faster operation. Electronic storage companies typically host your electronic information, encrypt it for security, and allow you to access it from multiple electronic devices, such as desktops, laptops, and smartphones. Reviews of cloud storage companies are available online. Dynamic files change whenever you enter new data. If you work on dynamic files that are or may become relevant to a lawsuit, such as a spreadsheet or a proposed agreement, consider making a backup every time you open or alter the files. Websites that may provide helpful information about electronic discovery include eDiscovery for Everybody, the Edna Challenge, Preserving Electronic Data by Stephen Silverman, and the Electronic Discovery Institute's website at ediscoveryinstitute.org. A request for a document must be precise enough that the recipient can reasonably determine what you want. For example, a request to, quote, produce every document that has anything to do with the case is likely to be objected to as vague. The requirement that your request be specific often means that you have to delay sending out a request for production of documents until you know enough about the case to identify the documents you're after. On the other hand, a recipient can't avoid furnishing a document because, for example, your request failed to mention the weight of the paper on which it was printed. Here's another tip. It's proper to request documents you can identify. You do not necessarily have to know a document's exact title or even that it actually exists to send a request for production of documents to your opponent or issue a subpoena for production of documents to a third party. For example, you might serve a subpoena on a hospital, asking the hospital to send you copies of or to allow you to inspect and copy all records, reports, notations, charts, x-rays, results of medical tests, or any other document as defined above pertaining to General Hospital's treatment and care of Silent on February 13th through 15th, 2010. The obvious advantage of wording a subpoena this broadly is that it may well produce documents that you don't know about. A recipient has to allow you to inspect or copy a document as long as it's in the recipient's possession or control. The or control language is important. It means that a party can't play hot potato with a document, giving it to an attorney or friend and then responding, "I'd love to give it to you, but I can't. It's not in my possession." An example, assume you are a plaintiff in an auto insurance personal injury case. You might file the following request for production of documents on the defendant. Your reasoning is in italics at the end of each request. Plaintiff Lee Ismore requests that defendant produce the following documents for inspection and copying at Ismore's business office at 950 Campion Way, Leamington, Ohio, between the hours of 2 p.m. and 4 p.m. on March 31st, 2010. 1. The document of title, the pink slip, to defendant's Ford Explorer. Now this can help you prove that the defendant owned the car and is therefore legally responsible for your injuries. The defendant's automobile insurance policy that provides insurance coverage for defendant's Ford Explorer. Now this can help you decide whether you are likely to be able to collect a judgment in your favor. Third, any other insurance policy, including umbrella insurance, that insures the defendant against liability growing out of an automobile accident. Now this serves the same purpose as request number 2, which is that it can help you decide whether you are likely to be able to collect a judgment in your favor. Fourthly, receipts for and records of any repairs or servicing done on defendant's Ford Explorer during the 1-year period immediately preceding the date of the accident that is the subject matter of this lawsuit. Now this can help you decide if the defendant failed to make necessary repairs or whether a repair shop or parts manufacturer might also be liable for your injuries. And fifthly, defendant's appointment book for the date of the accident. This may help you prove that the defendant could have been distracted at the time of the accident, as might be the case if the defendant was late for a critically important meeting or had just received disturbing medical news. Here's a good resource: American Jurisprudence, Pleading and Practice Forms, Annotated, and Basics of Legal Document Preparation. Requests to examine objects or inspect lands or buildings. Discovery rules generally also allow you to request production of things and to request entry on an opponent's land to make an inspection. For example, if you claim that you were injured by a piece of poorly designed automotive equipment, you may request that defendant produce the Share 9000 tire inflator for inspection and testing at the offices of Burbage Testing Labs at 30 Clifton Avenue, Coventry, Maryland, on June 3rd, 2011. Or if you claim that a ditch dug by your next door neighbor is improper because it causes flooding on your property, you may, quote, request that the defendant permit plaintiff and plaintiff's engineering expert to enter defendant's property located at 229 Elm Drive on March 27, 2011 at 2 p.m. for the purpose of inspecting and photographing the property. You or your adversary may respond to a request for production of documents in a variety of ways, depending on such factors as convenience, the way records are kept, and the number of records. Standard ways of responding include any of the following: mailing copies of the documents to the requesting party with the sender bearing the copying costs. 2, bringing the originals to the requesting party and letting that party pay to make copies. 3, when the records are voluminous, making them available at the place where they are usually stored and allowing the requesting party to inspect and copy them. However, the recipient of a request to produce cannot, for example, ship documents to the North Pole and tell the other side to go there to inspect them. 4, objecting. Common objections are that a request is unduly burdensome, that is too much trouble given the amount of money in dispute, or vague and overbroad. And then fifthly, replying that there are no documents in the possession or control of defendant that correspond to plaintiff's request. And then finally, request for admissions. Requests for admissions are written statements or assertions that you prepare and serve on an adversary to secure the adversary's admission that facts are true or that documents are genuine. See Federal Rules of Civil Procedure 36. Most states have similar rules. Requests for admissions are not designed to discover information from an adversary, but to make life easier at trial. That's because once you or an adversary admit that a fact is true or that a document is genuine, the admission can be offered as evidence at trial and cannot be disputed. For example, in an auto accident case, you serve the following requests for admission on the defendant. 1. Admit that the following fact is true. On February 29th, defendant Sarah Adams consumed 2 martinis between the hours of 9 a.m. and 10 a.m. And secondly, admit that the following document is genuine. A letter dated March 1st and signed by Sarah Adams. If these requests are admitted, either because the defendant answers them affirmatively or fails to deny them within the set time by law, often 30 days, you can offer the requests into evidence to prove that Sarah Adams consumed 2 martinis and wrote the March 1st letter. Moreover, the defendant cannot try to contradict this evidence. As a self-represented litigant, you must be especially alert if you are served with requests for admissions. First, you must respond in writing within 30 days, or everything in the request is treated as though you admitted it. Second, you cannot automatically deny every request, figuring that, hey, I can't lose by denying. To the contrary, if your case goes to trial and your opponent proves a fact to be true or a document to be genuine after you denied it in a request for admission, the trial judge can force you to pay whatever it cost your opponent to make the proof, including attorney's fees. See Federal Rules of Civil Procedure 37, Section C. If you don't have a document or are uncertain as to how to answer a request for admissions, often the safest course is to respond by saying that, quote, I neither admit nor deny the requested fact because I do not have sufficient information to do so, unquote. This will usually protect you against having to pay your adversary's expenses for proving that the fact is true, unless a judge concludes that you answered in bad faith or could have readily found out whether a fact was true or a document genuine. Requests for admissions are usually served near the end of the formal discovery period. If you serve requests on an opponent before the opponent has had a reasonable opportunity to investigate the case, your opponent will almost certainly deny them or answer by citing lack of sufficient information. And the judge is unlikely to penalize the opponent for failure to make admissions at this early stage, even if you prove at trial that a fact is true or a document is genuine. Similarly, it is not usually until case investigation is nearly done that you can identify the facts and documents that you want to include in a request for admissions. So we will leave off there today. Our next video, video 6, we will be discussing settlement. And we'll go over court-ordered mediation and arbitration, offers of judgment, pre-trial, settlement conferences, and post-settlement documents. So thank you for spending this time with us, and we look forward to meeting with you in our next video. Until then, be blessed.